It never ceases to amaze me how much things change and how quickly things change. A few years ago, we gave out information. I gave out information in regards to how long to keep medical records, and since then, it has changed. So this is all new information, and the short answer is this. Here it is. You want to keep your medical records for 10 years or until the patient reaches 22, whichever is longer. So if you're treating a newborn, you're going to keep the medical records until that patient reaches 22. If you're treating a 15-year-old, you're going to keep it until they reach the age of 25. Basically, it's 10 years past the last date of service for that particular episode of care. And that's how long you keep your medical records. Now, where does that come from? Is there a specific statute? Is it easy to point to? No. That's the short answer is no, because a lot of doctors say, well, HIPAA says I only have to keep them for 6 years. Well, no, HIPAA actually says you have to keep them for a minimum of 6 years. So that's your rock bottom minimum. Then you have to look at all of the other considerations that matter for you in your office. And that is, you've got to determine, okay, what are some of the other legal ramifications for other providers in Illinois? How long do they have to keep their medical records? Are there statute of limitation issues? What about malpractice questions that may come up? Insurance claims and things along those lines. What does all of that look like? And when we look at the whole picture, we look at case law, statute of limitations, and other providers and what their legal requirements are. That is where we've come up with the answer. For example, although HIPAA says 6 years, actually hospitals in Illinois are required to keep their medical records for 10 years. There are other provisions that require, in certain circumstances that don't apply to you as a chiropractic physician, that they have to keep those particular records for their entire lifetime, for the lifetime of the patient. And so that is a really important piece. So we look at all of those pieces together, and that's where this comes from. So again, the answer is 10 years or until the patient reaches the age of 22, and that is past the last date of service for an episode of care. That's how long you keep the medical records. Now, are there other exceptions to that rule? Yes, there are other exceptions to that rule. If you have someone who is mentally disabled, or disabled is the way the statute reads, then you have to keep those medical records for their lifetime, basically indefinitely. Typically, what it says is you have to keep those until the clock doesn't begin to tick until that patient's disability is removed. So if you have somebody that is fully disabled, then you have to keep their medical records until the disability is actually removed. So for a lot of patients, that's going to be for their lifetime. So that's something else to keep in mind. Additionally, this is also important as we continue to move more into a technologically based age and more doctors are utilizing EHR. Then our typical recommendation, if you're utilizing EHRs, go ahead and keep the medical records indefinitely. And that's because you always will then have backup and proof if there's ever any questions. And although some of those other issues begin to go away with the statute of limitations, if there's ever other questions that come out, because sometimes those statute of limitations can be broken through in cases of fraud and things along those lines, then you just are fully protected. You have those longer term medical records as long as you're keeping them electronically. Really, data space storage is pretty inexpensive versus a lot of the paper storage, which used to be the biggest issue. So again, the answer is 10 years or until the patient reaches the age 22, and that's how long you have to keep them. We'll catch you next week.